Well, hello, and welcome to the second in the series on ethical violations in the family courts. This particular segment will deal with Standard 2.04, the bases for scientific and professional judgments, essentially the application of knowledge. The APA Ethics Code Standard 2.04 says that this is mandatory. Ethical standards are not optional for psychologists, they are required. So psychologists' work is based upon the established scientific and professional knowledge of the discipline. The relevant scientific and professional knowledge of the discipline for the pathology in the family courts includes the following: the DSM-5 from the American Psychiatric Association, the literature, scientific research about attachment and attachment pathology in children, that's from Bowlby and others, personality disorder pathology, specifically narcissistic, borderline, and dark personalities. That's Beck and others. Complex trauma and child abuse. That's from Vander Kolk and others. Psychological control of the child. That's from Barber and others. And family systems from Mnuchin and others. And I want to particularly emphasize the DSM-5 from the American Psychiatric Association. Let me say something about that, because if you do not, as a doctor, if you do not make a formal professional level diagnosis of what the problem is, then that's you're risking incredibly increases the risk of potential misdiagnosis because you haven't applied the diagnostic criteria to your diagnostic formulations and professional judgments. The DSM-5 from the American Psychiatric Association represents the established scientific and professional knowledge surrounding a number of pathologies, including persecutory delusions, factitious disorder imposed on another, and child psychological abuse is also a DSM-5 diagnosis. Now, if as a forensic psychologist, you do not list or name or identify your professional level DSM-5 diagnosis in your report, then you are indicating to the court and to everyone involved that there is no diagnosable pathology present. Because if there was a shared persecutory delusion, you would have told the court, right? And you would have told the two litigants that this is a persecutory delusion, right? If it was a factitious, false attachment pathology being created in the child for secondary gain to the allied parent, factitious disorder imposed on another, you would have diagnosed that and told the court, right? You would have diagnosed that and told both the litigants it's a factitious disorder so that the targeted parent could press their case to the court for a child protection response, right? If it was child psychological abuse, V995.51 in the DSM-5, you would have diagnosed that and told the court and told the parent litigant, right? So the fact that there are none of these diagnoses listed would indicate that you are saying that none of those diagnoses are present based on your assessment. Now, in addition, if there is no rule out R/O diagnoses for a persecutory delusion, factitious disorder imposed on another, or child psychological abuse, and spousal abuse of the targeted parent using the child as a weapon, if there's no rule out for any of those diagnoses, then you are asserting that there is no possibility of any of those. Because if there was a possible delusional disorder, you would have put it as a rule out and informed the court, right? Or a possible fact that you rule out, you would have informed the court and the litigants so that we could get a proper assessment for the delusional thought disorder or factitious disorder. And if there was possible child psychological abuse, you would have put it as a rule out and informed the court that it's a consideration relative to one of the parents. But because you didn't list any of those, you are asserting that they are not even possible. Because otherwise you would have told the court, right? The professional standards of practice in the forensic psychologists in the family courts are considerably substandard. Google ignorance, lack of knowledge or information. Google indolence, avoidance of activity or exertion, laziness. Because the forensic psychologists do not know the knowledge required for competence in violation of Standard 2.01, they then do not apply the established knowledge of professional psychology, which they don't know, as the basis for their professional judgments in violation of Standard 2.04. Then that creates a cascading set of ethical violations from 2.01 to 2.04 to 9.01. Because the forensic psychologists do not know the necessary knowledge required for competence in violation to Standard 2.01, they then do not apply the established knowledge of professional psychology as the basis for their professional judgments in violation of 2.04. And their opinions, as contained in their recommendations, reports, diagnostic and evaluative statements, including their forensic testimony, are therefore not based on information, Standard 2.04, the DSM diagnostic criteria, and the attachment pathology and family system, and not based on information and techniques sufficient to substantiate their findings in violation of 9.01. 2.04, to remind us, it says, psychologists' work is based on the established scientific and professional knowledge of the discipline. The established scientific and professional knowledge of the discipline is the DSM-5 from the American Psychiatric Association. The relevant diagnostic considerations are 297.1, a delusional disorder, shared persecutory type; 300.19, a factitious disorder imposed on another. That's a factitious attachment pathology imposed on the child for secondary gain to the allied parent. And V995.51, child psychological abuse. There's also additional established knowledge from attachment and family systems and personality disorders and complex trauma and a variety of other relevant domains. Educating the doctor. If a doctor needs to be educated about the pathology, its diagnosis and treatment, then that doctor is not competent in that pathology by a demonstrated need to be educated about it. They are ignorant. They lack knowledge and information. And if they have taken no steps to ameliorate and eliminate their ignorance and to become knowledgeable, then they are indolent. They are resistant to exertion and lazy. Relying on new pathology labels. If a doctor relies on made-up pathology labels for symptoms that the doctor does not otherwise comprehend, then that doctor needs to be educated about the pathology using established scientific and professional knowledge of the discipline. And if a doctor needs to be educated, they are not competent in that pathology. There is no new pathology unique to the family courts that exists nowhere else in society that requires its own unique new pathology label and symptoms. That doctor who's using those made up pathology labels is simply hiding their ignorance, their lack of knowledge and information about real forms of pathology. And they must, by using these made up pathology labels of their own devising. So, with that, that is essentially the violation to 2.04. Everything is cascading off of their fundamental violation of standard 2.01, boundaries of competence. They don't know the necessary knowledge. They are ignorant of the necessary knowledge, lack knowledge or information um, based on their education, training, and experience. If they don't know the knowledge, they cannot apply the knowledge. If they don't know and apply the knowledge, then that will lead to the violation of standard 9.01, which is the next violation in this series.